got to be ready to go on that date. But if they go, then you don't have to go, so it's stand down. But you, as the person who pays your attorney, you have to pay them to prepare to go to trial twice. And that can be very expensive. It's because the legal system, the judges, in my opinion, just do not stand up and put a stop to all this monkey business and hold the other side accountable. If you bring a frivolous case and it's found to be frivolous, you pay. And I'm not talking about the plaintiff. Yeah, he should pay, but you make the attorney pay. Okay? You make the attorney pay. Make the attorney feel some of the pain, what you're going through when they're representing these people who are bringing claims that are frivolous. But that's not the way our system's set up because there's too many attorneys in the legislature. All right, receiving bad advice. So this is another problem. People get bad advice. 2 years ago, I was in San Diego, and I was asked to come speak at I forget, there's a town a little north of here, or no, actually it's east of here. It's east of here, northeast of LA. And it's an investment club. I forget what the average individual, maybe $5 million or so in net worth to be part of this. It's called the Gentleman's Club. Has anybody ever heard of it? You have? All right, it's not one of those types, although Tracy, she said, you're going to speak at what? Some gentleman's club? Yeah, I bet there's a lot of structuring going on. I said, no, honey, it's all guys. She said, yeah, they're all sitting around watching women on brass poles, maybe. And I said, God, guys, can't you come up with a better term for your club? It's really hard for me to sell this to my wife, and I'm going up there for so-called work, which it really was. So I went up there on a Saturday morning to speak to this. There's 15 guys sitting around the table. And I spoke to them for about an hour and a half on asset protection. So I get done, and I said, normally I won't do this, but if anybody here would like to take my car, I'll give you a free consultation. I'll give you a 30-minute consultation, tell you what I think about your current structure. 15 guys, how many cars do I give them? What do you think, Terry? One? Okay, one. What do you say? You say 15? Why not? Free attorney? How often do you find an attorney willing to give something away for free? Okay? Never. All right? Never. I didn't give up a single car. 0 cars. Nobody collected my cars. Why? Because they have their local guys. Why do they need this guy from Seattle to come down here and tell me what I'm doing wrong when I have my local guys who know everything about what I'm doing, and they're local and they understand me? So I left there without one person asking to meet with me. Okay, so it was a Saturday, flew a few hours, flew back, no big deal. 2 months later, I get a phone call. Well, actually, somebody called in, and all of our voicemails go into our email, so I get back from lunch and I click on this voicemail, and it's this. Clint, this is Tim. It's imperative that you call me right away. You met me at the Gentleman's Club 2 months ago. I really need you to call me back. This is urgent. Please call me as soon as you get this message. I need to speak with you. Click. Oh, Clint, by the way, I didn't give you my phone number. My phone number is Please call me as soon as you can. Click. All right. What does that mean? Yeah, he's paying double. All right, so, right, you don't want to call 30 at that point in time. I call him up. Yeah, he's in trouble. He's in a lot of trouble. First problem is he's doing business in California, unfortunately. Okay, they make it way too easy to sue small business owners down here. You know, one of the claim that was brought against him is it's a type of claim now that a lot of attorneys that are personal injury attorneys now have latched on to, and that is a wage-related claim. They sue you basically stating that you haven't fairly compensated your employees. And the reason attorneys like these types of cases is because they get in trouble damages, they get their attorney's fees out of it, and there's huge penalties for the employer. So here's this guy, Tim, who's being sued, and they're asking for $1 million, saying they didn't pay overtime to a couple employees. Now, Tim had been involved in this lawsuit for about a month. They're asking for $1 million, and this was, his attorney told him just to pay. She said, you got $1 million? He said, yeah. She goes, you should just pay to make this go away because it could go even higher than this. And he said, well, what's your first advice to me? I said, fire your attorney. Yeah. Okay? First thing you should do is fire your attorney. Any attorney tells you to pay to make it go away is not representing your interests. All right, so get rid of her. He did. I said, now we need to look at your structure. Now, the problem he had is that his advice came from a CPA who doesn't understand asset protection. CPAs understand taxes, so he has this S corporation set up here that he runs his business out of. And an S corporation is a flow-through entity. So if your S corporation generates $1 million this year in profits, so you have $1 million inside of there, and you're the sole owner, so I'm down here, I'm the owner of this S corporation, I'm going to be taxed on all that $1 million even though I don't pull it out. I can leave it in there, but I still have to pay taxes on it because it's a pass-through. So, next year, if I pull that $1 million out of my corporation, there's no tax because I've already paid tax on that money. So I can pull it out wherever I want in the future. I'm not going to pay tax on that. With flow-through entities, you don't look at when you pull the money out to determine whether or not it's taxable to you. What you do is you look at how much money did you make that year, what percent of that company do you own. That's how much you have to recognize on your individual tax return. Whether or not you take it out, government doesn't care. They just say you made $100 million that year, you own 100%, you made $1 million, you got to recognize that on your 1040. End of story. So, his CPA told him, said, leave your money in there. Tim, you should leave your money in your S corporation because in our business, what we have is fluctuations with our receivables versus our payables. So we have a lot of payables, but we maybe have not collected all of our receivables from all the hotels that we've been doing all this work for. So we should have a nice buffer there to make sure we're always current with our suppliers so we don't lose our credit rating. So the CPA convinced him he should keep his money in his corporation. So he had $750,000 in cash in his corporation. His corporation is now being sued. What do you think he wants to do right away? Pull it out. I said, Clint, how do we get this out of here? I said, Tim, we don't. Okay? Let's just start with that right there. And then he said, well, I don't understand. You said you could help people in my situation. I said, you're right, I could have 2 months ago. Okay? You've just made it so that I cannot help you now because your business is being sued. And if we pull that money out, that's considered to be a fraudulent transfer. And they will just undo the transaction and make you pay it back in. Not to mention they're going to assassinate your character in front of the judge and tell them what a nefarious individual you are trying to hide assets, and so it won't bode well for you. So that money's stuck in that corporation. But since we're on the conversation, I'm going to give you my 30 minutes of advice right now. What you need to do once this lawsuit is wrapped up, and it will be wrapped up favorably for you, I believe that. I said you need to create a limited liability company here. We're going to create that limited liability company, not in California, because California does not provide protections for LLCs. All right, they do from inside claims, not outside claims. That means this: that if it happens inside of the box, okay, it stays in the box. Always a way to remember this: what happens in Vegas does what? Stays in Vegas. All right, so what happens in the box? Stays in the box. That's uniform across all 50 states. But it's what happens on outside of the box. Whether or not that stays outside of the box is so important. And that's where we look at the different jurisdictions and how they approach asset protection. California has taken an approach. You know, there's so many attorneys down here, they all got to eat. So if they sue somebody and they have an LLC, let them take the assets. It states it right in your statute. Right? Wyoming, Nevada, they don't have hardly eating. Well, they have some, but not a lot over there. So their attorneys aren't so concerned about eating. So they have their laws set up where if you sue somebody who owns a Nevada or Wyoming LLC, you can't take their interest from them. That's why I recommended he take his cash and put it over in a different LLC. So I said, what you need to do is pull your money out and put it over here in this LLC. So we'll lock it into this box. Now, his immediate pushback was, when I told him about this, he said, well, Clint, wait a minute. What happens if my business needs the money? You've got it locked over here in this LLC in Wyoming. How am I going to have access to it when I have to pay $200,000 to a supplier? Okay. Is that a fair question to ask? Yes.
Borrow it.
What'd you say?
Borrow it.
Absolutely, you can borrow it. Now, who decides if you can borrow that money? You do, right? How do you do that? You have a meeting. So you could be in the shower one morning, taking a shower, and you can hold your meeting right then and there, right? You're going to be washing your hair and decide, well, maybe not you, but some of us were you. So you're washing your chest, and you decide, hey, I'm going to loan myself money. There you go. You get out of the shower, you dry off, and then you go sign some paperwork saying you got a loan. That's simple. But you don't have to go that far. You can just take the money out because you're in control of this entity here. You're in control of this, and you can take a distribution to yourself right here and then pump it right back into your corporation. That's why whenever you set up entities, always use the same bank for all your entities, even for yourself. Okay, I use Wells Fargo. Now we're up to 31 accounts with Wells Fargo. And when I log in, I can bank on my phone. Yeah.
Is there a big difference? I'm sure there is between a capital contribution and borrowing.
There's a big difference between a capital contribution and borrowing from the standpoint that with a capital contribution, you have no asset protection. If you wanted the asset protection, so the follow-up to this, which I wasn't going to go into, but what the heck, what you said, sir, was to take a loan. So you can have your S corporation borrow money from the LLC, and then you treat it like a traditional lending relationship where your LLC will then file a UCC-1 financing statement against your own business. So you granted this lien over all of your receivables. So if somebody sued your company in the future and you have $500,000 in receivables still coming in, they're owed to your LLC to the amount of money that you've extended as far as credit is concerned. It's no different than what a bank would do. I just helped a client this past week. Okay, I provided an attorney's opinion letter on a commercial loan here in California. It's a $4.4 million loan, and the bank is filing 2 UCCs against his business in exchange for that loan. Because they just want to ensure that if he quits paying, that they have some way to collect against the assets and the receivables of this company, because it's traditional business. So you can do the same thing. But the key here, this is an operating business, the S Corporation. Take it out of what I have here, a tub glazing business, put it in the real estate context. That corporation right there is your flipping company. If you're flipping properties, that's the one that's out there buying and selling the real estate. Now, if you have cash that you personally put into your own deals, you could contribute it. But if you make a contribution, contributions are not protected. You're the last person to get paid. Or if you have an LLC, which is the way I do it, I keep all my cash in a limited liability company. And whenever I put a deal together, my LLC is going to loan money to that entity. And then it's either going to take back a first or a second position in that deal, okay, depending on what I have going on. So I've always protected my exposure to any risks associated with that individual property right there. So this was his solution after that lawsuit settled. He did settle. He settled for $10,000. He fired that attorney, got a new attorney, and they settled for $10,000 and made that case go away. What a big difference, right? The first one told him to pay $1 million. And I said, you should report her to the bar. She shouldn't even be an attorney. Okay? Now, receiving bad advice, that's a problem. So, let's go on. So the problem you have in California is this rule too, which compounds the issue. 1% at fault means you're 100% liable for damages.
Wow.
All right. Yeah, it's called joint and several liability here in California. Now you'll see how this plays out. I have there's a client that owns a very famous nightclub in Los Angeles. It's a client of mine. And 2 years ago, there was a situation where an individual had left the club and had been given the keys to the car by the valet company. And once he got the car, he didn't put it in reverse, he put it in forward accidentally, and then accelerated into the building. Well, it just so happens there were 2 patrons walking along the side of the building when he hit. One guy loses 2 legs, the other guy loses 1 leg. Who's at fault?
The building.
Owner of the nightclub, right? See, this is a problem. We've all been conditioned now in society to say, oh, it's the owner of the building, owner of the property, owner of the nightclub, okay, valet company. Nobody says driver any longer. When my grandfather started practicing, they would say, that's simple, it's the driver of the car, end of story.
He was drunk.
Yeah, whatever it is, he's at fault because he's driving the car. Okay, my grandmother used to say, you know, when I started practicing, you actually had to do something wrong in order to get sued. Not any longer. Because we go after the deepest pockets. That's what we attorneys focus on. The driver, nobody sued the driver in this case. Okay? The driver's wearing orange, he's somewhere else, right? He's behind bars, nobody wants to go after him. He has no assets. So who do we go after? Valet company. We go after nightclub owner. We go after building owner. So here's what happens. Nightclub owner is my client at this point in time. They're suing for $10 million. They settle with the valet company for $500,000. That's their policy limits. They settle with my client for $1 million. That is his policy limits. Now, even then, that was questionable because his insurance company reserved the right not to cover him because in his insurance policy, it stated that if he ever brought in a valet to manage the cars on the property, the valet's insurance must name his insurance company as an additional insured. Well, he didn't read page 18 in 4-point font in his insurance policy to know this. And of course, the insurance company pointed it out to him when he brought his claim to them. But this is one of those times when the insurance company did the right thing. I got plenty of stories where they don't do the right thing, but this is when they did the right thing. They paid out full policy limits of $1 million to the 2 individuals. So now they turn their sights on building owner. Building owner happens to be my client's father. He's 92 years old. And he offers up his insurance. He says, I'll pay you the $1 million. They say, no, we won't take it. They would not take his policy limits. They wanted more. And he said, well, basically, piss on you. I don't care. I did nothing wrong here. I own the building. My son's running the club. You got a valet company right there parking car. I did zero wrong. You haven't alleged that I did anything wrong. And I had to sit him down. I said, you understand. I completely agree with you. But at the end of the day, they have to show you're just 1% negligent. If they get a jury to buy off on the fact that you were 1% negligent, you're going to be liable for 100% of the damages in this case. And I would put to you that they're probably going to find a jury that will hold you 1% negligent. He goes, I don't believe that. I said, look who serves on juries nowadays. Okay, it's not people that have a JOB. Okay, that typically doesn't align with JURY. Those people are one. You know, I've been there. Questions that were asked from the jury. Do I get a free meal on this? Okay, that's their minor concern. What do they say from the jury? Do I get a free lunch? Do I get a bus pass? Right? And I've been on a jury duty. I've been on a jury before, and it was shocking. The people, what they had to say about the case, because everybody brings their own biases to a jury. I mean, just think about it. Anybody here a doctor? No one? You know, a dentist? Any professional? All right. Well, just if I was a doctor and somebody's bringing a negligence claim against me, I would like to see everyone on that impaneled jury all be doctors. Because who else is going to understand the situation I'm in unless you're a doctor? You think you can understand the stress that a doctor's under in the ER when he's doing something on someone? No, you don't. I can't pretend to understand that. But that's not the way our system works. We don't allow doctors to sit on juries because they're too smart. Especially when you're dealing with another doctor, they'll exclude you. They say you have too much knowledge, sir, so you can't be here because you would influence the other jurors. So that's why, you end up getting people on there that come up with these crazy decisions that we all scratch our heads on and say, how do they determine that? Well, look at the collective hue of the jury. You probably figured it out. But anyways, so this is the situation you have. The reason they wouldn't settle with him is because they ran an asset search on him in LA. And they said, you're worth between $25 to $35 million. Because everything he has is in his own name. Everything he had was in his own name at that point in time. So he had to pay. Because he didn't understand, I'd structured his son. Now his son is worth probably twice as much as his father. They didn't know that. Because everything that his son owns is completely protected. And his name's not on anything. Not on anything, because of the way we set him up. Father, at that point in time, everything was in his own name. All right, so that was a problem, because the father was sitting back. He's from Japan. He came over here, I think, in 1950. And so, he has a different culture. And he's not willing to just automatically accept me as someone who can provide services to him at the time. So he wanted to see what I could do for his son, and that I was a trustworthy individual to work with. And so it wasn't until I built that trust, and he saw that his son didn't have to pay money, I think more than anything, that he said, help me, And we got him structured. And then he went out to clip somebody in the sidewalk. So, yeah, he did. And they're calling and saying, Clint, I'm so thankful we met you and you did what you did for my dad. So that could be a problem. All right. So what we want to do is we want to use strategies for risk reduction.
Just one quick question. As a professional attorney, your experience, do you feel that professional jurors would make a difference?
Yeah, I think so. Definitely.
Think we'll ever see that?
Nope. No. And maybe raise the bar for becoming an attorney. Here's my son. My son just went off to college, first year off of college. He's going to Seattle University. And he's in their pre-law program, so he can get out of school in 6 years. Well, originally he said he had interest in being an orthodontist. I said, I encouraged him to go down that route. I said, this is a great profession for you. You should become an orthodontist. And he thought about it and did some research, and he came to me one day and said, Dad, I looked at it, and it's so expensive to become an orthodontist. It's so much time, and I look at what you do. All you need is a computer. You go out and speak, and I see how much money you make. I want to be an attorney. All right, that's how big I am. But they let allow too many people in the law school. Because law schools are money makers for colleges. There was an article in the Wall Street a couple of years ago that major colleges are shutting down their engineering schools and opening up law schools because they can make so much money off of it. So you pump out all these attorneys, what do they have to do? They got to make money somehow, and they sue people. Or they just bring frivolous cases. So it's perpetuating itself.
So out of the $25 million, what would he end up paying?
Out of the $25 million, what did he pay
To the
another
father.
$5. He paid under 5. Paid under 5.
But plus the valet and plus,
Oh, yeah, oh, yeah.
so,
They didn't collect the full 10 million, and he went on a payment program because he has lots of property, just not tons of cash, because he's under rent control on a lot of his properties, and so he's not pulling in a ton of money. It's a lot of it's self-imposed rent control because he's such a nice guy. He hasn't raised his rents on some people in 15 years, 20 years. So it's just the person type of individual he is. So he's not rolling in cash, but he's just really rich from an asset standpoint. So what we want is risk reduction, all right? Because if you reduce your risk, then you can take on more risk. Now, I started off with this slide, and maybe you can't see it up there, but you know, when you reduce your risk, you're able to do so much more because you're not always looking over your shoulder thinking, if I take on this additional risk, oh, if something goes wrong, everything's going to fall apart on me. You know, I find it comical. Banks will ask me for personal guarantees. I basically have pre-printed. Here you go. Here you go. I don't care about giving you a personal guarantee because you could sue me tomorrow and you're not going to get anything. I mean, you'll get what's in my personal bank account. Yeah, that's fine. I don't keep a lot in my personal account because the way I've structured myself, I've made myself judgment proof, basically, because it's not how much they win, it's how much they collect, and they're not going to be able to collect a lot against me because I don't keep a lot in my own name. So you do this through risk reduction. Now, what attracted me to this particular slide is about 3 years ago, there was a guy who was going to do a high wire act across the Niagara Falls. And I told Tracy, I said, hey, hon, we're going to watch this tonight. I said, we're recording it. This is going to be awesome. And so I'm all excited to watch this guy cross the Niagara Falls. And I'm just sitting there, you know, for the whole 30-minute build-up to it. And everybody's standing outside. And I'm just like this. And I said, what the hell's that on his ankle? Is that what I think it is?
Yeah.
Yeah. He was tethered to the line. All right. Now, my interest in that program evaporated. Yeah, did I want to see him? I didn't want to see him fall. But the possibility of him falling made it interesting. Once you eliminated risk, no interest for me. Because he could go out there and dance around and do all this. Who cares? Do whatever you want. Sprint across the damn wire for all I'm concerned because you're not going to fall. You've eliminated that, so there's no more risk in what you're taking on. Well, what I'm going to do for you is eliminate the same amount of risk by tethering you to a line with the proper asset protection tools. You can do the same thing. So you want to go out there and sprint around the high wire and don't fall? Great, you can. So we call this attorney be gone. Okay? When they see it, they don't like the smell of it. Okay? So the way that sets up is like this, right here. All right. So there's a couple different ways in which you can protect yourself. First way we start off with is getting your name off the title. All right? If they don't know you have it, they're not going to know what to come after. So for instance, my client's father, everything's in his name. They went after him, full action on him. My client, they didn't touch. They walked away with the insurance, okay, because they didn't know what he owns. Had they known what he owned, they're probably going after him for a heck of a lot more because he could pay it. And he has a ton of cash because in his business, it is a cash. The thing prints money. 40 grand a night, that type of money. That's how much business this company runs. So they don't know that because they don't see it. And it's protected in a way that they couldn't get after it. So how do we accomplish the same thing for you? Well, it starts with planning at the outset. You have to do it right from the outset if you want anonymity. Sometimes it's hard to go back and fix things. So once the genie's out of the bottle, you're not putting that genie back in. If you haven't done it the right way. And unfortunately, when we talk to a lot of people, we find that they've started creating structures and they're working with individuals who do not understand the importance of keeping the genie in the bottle because that's just not the way they operate. They are more of, I'm going to give you accurate information, but it's not going to be relevant because I myself am not engaging in that type of investing, so I don't understand your business. You're talking about wholesaling. I heard you brought up wholesaling. Right, how do you wholesale properties? You go to an attorney and say, many times they'll say you can't do that. You have to be a licensed agent. No, you don't. What is your extensive knowledge of wholesaling? How do you think it's supposed to be set up? I mean, has anybody wholesaled a property before?
Yep.
Okay. And what did you do?
Principal of the contract, match them up.
Okay. Are we using CAR forms?
California, well, actually, I never bought the property.
Okay.
I never rehabbed the property.
Okay.
So there's a difference in flipping from that standpoint.
Okay. So let's say you enter in years in a CAR form to tie the property up on your contract. Okay. All right. There's a non-assignability clause in there. So people tell you, well, you can't assign it the contract to somebody unless the seller agrees. Well, there's truth in that, or correct, the seller has the right to say no, but if the seller wants to sell the property, what do they care? Right, if they're gonna get paid. The only time you're gonna possibly run into problems with that if you're in a hyper market where the property is significantly appreciated, which does happen in certain markets. I mean, California, notably in 2003 up to 2007, you had hyper markets down here. Vegas, we had hyper markets. And so a seller would oftentimes, if they knew about it, when somebody has signed their contract, they say, hey, I don't want to close because I can sell it to somebody else now and make another $75,000 in 60 days. So if you give me a way out now, I'm going to take that option and get out of this because you violated that assignability clause. So if you want to assign a contract, then it's real simple if you understand the basics of what it is you're doing. If you look at it as assigning the contract and there's a non-assignability clause in there, right, the seller has an out, the attorney who gave you that information is 100% accurate. Freaking he doesn't understand your business or how to set up structures that will protect you. Why not do this? Why not, rather than enter into the contract in your own name, enter into the contract in an entity or in something else? So you're not the one tying up the property. You have created, many times I've seen real estate investors use limited liability companies to do this. And I don't use LLCs because it's too expensive to set up LLCs, especially in California, it's $800 plus the fine. Basically you're out $1,000 to go out and put together an agreement, a wholesale agreement. So what I created maybe 6-7 years ago was a wholesale trust, just a little trust. So I tell people, take title in the name of the trust, and then rather than have to assign the contract, you don't have to sign the contract. What you do is you hold title in the name of this trust. You have the right, the trust has the right to close. You give the trust to somebody else. They buy that trust from you, then they get to go in and close on that deal because it's the trust that tied up the property. And what got me started in this area was people who are buying HUD properties. They're wholesaling HUD deals. And HUD will only close in the name of the individual that wrote the agreement. All right, that's on the purchase and sale agreement. They will not close on a third party's name. You'd have to do a double close, and that's just too complicated. But if you put it initially in the trust name, then you just flip the trust. That's another name I've called it on occasions, a flip trust. You just flip the trust to somebody else, and they get to close in the name of the trust. Yeah.
Could you flip a lease purchase in a trust, just like wholesale?
You do anything you want.
So you would
Your answer.
As long as you can make it complicated. You can use limited liability companies. That's just complicated, expensive, and it's not the way I would go. But I would use something that's simple. A wholesale trust, flip trust, simple thing to do because it's a trust that controls whatever agreement you enter into. Whoever holds the trust owns the right under that agreement.
So you'd write that up as the trust and or assignee?
No, we don't even do that because the trust is the one that's going to close on the property. So it's XYZ trust. So that's always going to be. The question is, who owns XYZ Trust? Initially I did. What's your name?
Cynthia.
Now Cynthia owns it because I sold it to you for $10,000. You become the beneficiary. You control the trust. So you go to closing in the name of the trust. So then Cynthia title's taken in the trust name. What really got me interested in this was starting HUDs and REOs. So I was buying REO properties, and it wasn't because I was so interested in my clients, but it was for my own deals. Because what I will do is I have this set up. Remember I said I have an LLC set up with all my cash, just like this. And I would enter into the deal with this LLC with the intention then to flip the property to close in the name of this LLC right here, closing. Bank said, no, we won't do that. You have to close in the name of the entity that originally put the deal together with us. Yep. So they forced me into a situation where I couldn't do that. So then I said, okay, I created these LLCs, so I had a whole bunch of LLCs created. I do one property per LLC. That's why I have so many bank accounts, because it's just one property per limited liability company is the way I operate. So now I had created several limited liability companies, and these are the deals I was doing in Nevada. So I had them all set up, opened up an account with them, small amount in the account, went and would enter into a contract for purchase with a bank on an REO property. But I didn't have enough money for the earnest money in that account, so I'd write the check out of this LLC for the earnest money. Bank would then look at it and say, wait a minute, we see that XYZ LLC is on the contract, but the money came from ABC LLC. We won't close an XYZ, we're only going to close an ABC. And I just got so frustrated with dealing with banks, that I said, you know what, I'm gonna use the same thing I use for people that buy HUD-owned properties, I'm gonna start doing my wholesale trust. And so that's how I started setting these things up, just because I didn't know if I wanted to put the property in this LLC, or this LLC, or this LLC at the end of the day. Yes.
Can I pay Anderson advisors for setting up a trust on a lease to own?
Yeah.
I will be contacted.
Okay.
You just save thousands of dollars.
Don't ever tell me how much I save, because then the prices go up, right?
This is gonna be great interest in everybody sitting here.
All right.
So you just do an amendment to change the beneficiary?
Yeah,
Okay.
you just assign it, you assign the beneficial
And
interest.
that's what you just say, having